All right, so Federal Fair Housing Act, assistance, animal or pet. That's really the key question here. Those are the terms we're going to use, and we'll get into sort of why and what those mean. So now we'll start with the basic gist of what we're doing here. The United States wants to provide fair housing for everyone. Great. Fully in support of that. What does that really mean? How does that work for us? How does that look? Department of Justice, DOJ, Department of Housing and Urban Development, that's HUD. You're going to hear me say HUD a lot today. It's a weird sort of acronym, but that's who we're talking about. Those are the departments that are responsible for enforcing the Federal Fair Housing Act. So for the most part, like I said, you're going to hear me say HUD. That's usually the entity, the agency that we're talking about. There are local HUD agencies in all the counties and all of that. So that's usually who we're talking about when we talk about sort of who's looking at what you guys are doing and where the complaints would go and who we would be dealing with on the other side. It's HUD usually. So Fair Housing Act. Now, again, this completely makes sense. Now it seems like a long time ago, but realistically, it wasn't that long ago that fair housing was an issue. And obviously, with the the history of our country, there were some issues with discrimination and all of these things that precipitated the need to have a Federal Fair Housing Act that prohibited that type of, behavior. So essentially, the Fair Housing Act prohibits discrimination in housing on the basis of these protected categories. And these are things that shouldn't surprise you. They're all constitutionally protected: race, color, religion, sex, national origin, familial status, and disability. Now, today, for the most part, we're going to be talking about disability. That's actually really what comes into play when we're talking about fair housing and assistance animal related things. But familial status it's interesting to note that really has to do with age for the most part. And when you say familial status, that also has to do with families, as silly as obvious as that may sound, and whether a female is pregnant and whether there's a baby involved, and age comes into play when we're talking about housing for older persons. All of that is covered by familial status. But for the most part today, we're going to be talking about disability as the protected class here. Now, you also want to look at your local ordinances, your state ordinances. Some of the local ordinances, Palm Beach County, Broward, Miami, they add some extra categories in there. There's some specific changes or specific categories delineated. Age is specifically listed in Palm Beach County, for example. Sexual orientation, that's also covered by Broward and Miami, I believe. Marital status, gender identity or expression, that's sort of a more recent one. These are all protected categories that we need to be aware of and make sure, again, that there's no discrimination based on any of those things going on. When we look at, sort of where the base of all of these regulations are coming from, the federal code, we're talking about the United States Code, and then the Code of Federal Regulations, CFR. These are two different things, but basically they work together. United States Code has the statutes that Congress has enacted. Code of Federal Regulations has the rules and regulations that the governmental agencies have adopted. These basically work together. These are the regulations that we're going to be looking at and that we're going to be using as our guideline here. Now, and we have some introductions here, the rules that are adopted by the FFHA, those are contained in CFR, and there's a whole explanation here. It's Title 24, Housing and Urban Development. Again, notice those initials, HUD. And we're talking about Part 100 here, discriminatory conduct. And then we have all the subparts. When we talk about discrimination, handicap-related issues, housing for older persons is outlined in the same area, the same subpart. Discriminatory effect, that's something else that comes into play. And again, we'll talk about some of these things in more detail as we go. Now, I guess I should sort of back up. Quick disclaimer here. You guys are going to get a copy of all this information. We aren't necessarily, I'm not going to read every single word on every single slide because that would take longer than an hour and it would probably be super boring. So you'll have this, you can look back as a reference, you can read through it thoroughly, you can highlight it, you can, make your notes. but I'm just going to try and hit on sort of the more important things as we go. So we keep it moving here. All right. Fair Housing Act prohibitions. All right. So let's start from the beginning. Sort of what are we talking about here? Fair Housing Act, and again, federal and also Florida. They're really, when I say that, we're talking about both jointly, but prohibits housing providers, which does include associations. So housing providers, and you may be thinking, oh, that's supposed to, I'm sure that references, apartments. That means, whatever else. No, housing providers specifically includes associations as well. So HOAs, condos, all of that, from discriminating against housing applicants or residents because of their disability or disability of anyone associated with them. So not necessarily the owner of the condo. It could be a tenant. It could be a guest. It could be just another resident, an occupant, all of the people essentially that could be associated with a condo unit, with a house. If they have a disability, you can't discriminate against them. So important basic premise of this entire, course today. Can't treat those persons with disabilities less favorably than others. The Fair Housing Act makes it unlawful for any person to refuse to permit, at the expense of the disabled person, reasonable modifications, and we'll get into what that means in a minute, of existing premises occupied or to be occupied by such person, if such modifications may be necessary to afford such person full enjoyment of the premises. So again, we'll get into a little bit more detail on what that means. Fair Housing Act makes it unlawful for any person to refuse to make reasonable accommodations. Now, we've highlighted and underlined those terms because those are very important. Reasonable modification, reasonable accommodation, they are similar, but two different things, and we're going to get into them. So reasonable accommodations in any rules, policies, practices, or services when those accommodations may be necessary to afford persons with disabilities the equal opportunity to use and enjoy a dwelling. Okay. Now, there are some exemptions here for what Fair Housing Act, will apply to. There's exceptions here for religious exemptions, specifically a religious organization. Fair Housing Act is not going to prohibit them from limiting the sale, rental, or occupancy of dwellings that the organization owns, or giving a preference to such persons under certain circumstances. Private clubs also fall into certain exceptions here. A big one for our purposes, an important one for us, is number 3, familial status exemption here. Fair Housing Act does not apply to discrimination based on familial status with respect to housing for older persons, so the 55 and over, 62 and plus communities. Now that's important because, again, a lot of our clients, and probably a lot of you guys listening, are from housing for older person communities. Essentially, Fair Housing Act lets you discriminate based on age in those communities. And again, that's only in those communities. That's not across the board, because we're looking at age and we do have certain restrictions in place and we have to comply and all of that stuff. So if you're a housing for older persons community, essentially you're allowed to discriminate based on age and familial status specifically. So, again, it's the only time basically you can say to someone, no, we can't have kids here. We can't have anyone under 18 living here because that is the restriction. So there we are. That's the one that most applies to us here. Then there's some other exemptions. Again, you guys can read through this on your own. So ADA and fair housing comparison. What are we talking about? What's what? Because we get this a lot. There's a lot of confusion. When does the ADA apply? When are we talking about fair housing? Why are we talking about fair housing and not the ADA? Okay. These are two different things. Again, very similar and sort of overlap in a lot of ways. But the ADA deals with public accommodations, places of public accommodation, which for the most part, for most associations, that doesn't apply to you. So the ADA is when, we have to worry about what's happening in restaurants and in airports and in public places. Different when we're talking about condos and HOAs. Usually those are private places. Those aren't open for to the public usually in the same way. So again, a little different. So ADA prohibits discrimination based on disability. Fair Housing Act prohibits discrimination on the basis of race, color, religion, sex, disability, familial status, and national origin. So again, bit of an overlap there. They both are concerned with making sure we're not discriminating against anyone based on a disability. Now, again, little different on sort of how it's going to work and how they play out. When we're talking about assistance animals or animals in general, the ADA really only protects those with service dogs. Service dogs are a little different, and we'll get into how that, what those definitions are in a minute. Fair Housing Act does not protect necessarily just service dogs, but assistance animals are also included and protected and permitted under the Fair Housing Act. And a couple sort of technical differences here. ADA uses the term disabled, Fair Housing uses the term handicapped, but we'll get into that. They have essentially the exact same definition.
Emily?
Yes.
Sorry for the interruption. We do have a question, and it's from Christopher Carter. Could a lenient short-term rental policy in the building or community, and in parentheses, under 30 days minimum, change required compliance with the Fair Housing Act? And then in parentheses, it says transient public lodging versus purely residential owned property.
Yes, that's an interesting complication, and that's very specific and sort of highly technical legal question there. Generally not really covered here because it gets into a little bit more than we want to get into. But yes, there could be something where if you are a community that allows short-term rentals and it's in your documents, and this is something that's been permitted and sort of record of it, it may open you up to an argument that you are actually now subject to the ADA requirements in addition to fair housing. So that's what sort of changes things and could change the analysis a little bit. There are some other things that could change it. If your clubhouse is used for public events, things like that, it could change the analysis. But that's why I said typically, for the most part, the associations are more concerned with fair housing. ADA is probably not going to apply, but talk to your attorneys and make sure you are on the right page with that. So thank you. It was a good question. So handicap and disability. Fair housing, like we said, uses the term handicap. ADA uses the term disability, but they have the exact same meaning. The ADA essentially used the same definition for handicapped that was in fair housing. So even though the terms are used sort of one and one, they're essentially interchangeable because they're defined the same. So just keep that in mind. For handicapped, so again, that's what we're going to be talking about, here. This is the definition, and we'll break it down further in further slides here. Handicap means, with respect to a person, a physical or mental impairment which substantially limits one or more major life activities. So a physical or mental impairment, doesn't have to just be physical, or mental impairment which substantially limits one or more life activities. A record of such impairment or being regarded as having such an impairment. Okay. Does not include current illegal use of or addiction to a controlled substance. That's a little asterisk moment there. Now we'll break this down a little bit more. What does that really mean? Physical or mental impairment. Now, again, it's important, and we don't have to read all of the terms here. That's a lot of words on the screen, I know. But basically what you need to know is it could include, the things you normally think of in terms of a physical impairment. If someone has issue seeing, if they're blind, if there's a neurological issue, there's a respiratory issue. Those are sort of the things we typically think of when we talk about a physical impairment. But we also want to keep in mind mental impairments, and that's a little different. And we want to make sure we're keeping those things in mind as well, because that's usually for the associations what's probably going to come up for you. So any mental or physiological or psychological disorder, now again, that can include something like, as it's listed here, epilepsy, cancer, even diabetes. Those are things that people typically think of when they think of sort of medical issues, and okay. But there are other mental illness, emotional illnesses, those are covered as well. So again, if you have an issue with anxiety, depression, those could still be things that are covered and considered a mental impairment. Now, I point that out because that's usually, again, what we're seeing most likely is some sort of emotional or mental illness, typically when we talk about what applications you guys are going to get.
I
Not
have
all, typically, yes.
Emily, apologies. So, Mr. Brian Glenn is asking to be, we are a 55 and over HOA with a cafe. Can we prohibit a resident from entering the cafe with an emotional support animal, not a service dog? And assume that the resident
Guys are
can't.
getting highly technical. Can we get through this first?
Okay, gotcha.
That is quite specific. So
Yeah.
you have a cafe. Now we're sort of changing things. I don't know that necessarily whether that would be an ADA issue or whether we're staying in fair housing, but we'll get into fair housing and the rules you can have for an assistance animal sort of towards the end. So is that okay? Can we get back to that or sort of circle back, Jerry?
Yeah, absolutely. We can do that.
Okay.
And we do have an add-on is dementia included. It's again, specific. And then what types of animals? You know, cats, dogs, birds, pigs.
We're getting all that, guys.
Yeah. Yeah.
We're getting there. We're getting there. But like I said, we are, this is a 101 course. So let's sort of slow and steady. So we're breaking it down. We're starting with definitions. Major life activities. When we're talking about major life activities, we mean, and this is something you guys can, sort of figure out on your own, but functions like caring for yourself, performing tasks, walking, seeing, hearing, speaking, breathing, working. Those are all things that have to be impacted by this impairment in order to qualify. Now, having a record of such impairment or is regarded as having an impairment have two slightly different, definitions here, but basically there has to be a history of or a record of this impairment that is limiting the one or more major life activities. We'll sort of skip through so we can get to the good stuff for you guys here. Now, important questions, important things to be aware of, and let me back up a little bit in general. If you have, and we'll get into how the questions work and what you can ask and all of that good stuff. If you have anyone who seems to indicate to you, if you're on the board or if you're the manager and one of your owners or one of your residents, one of your tenants indicates to you that perhaps they have an assistance animal or they have a request about a reasonable accommodation or a reasonable modification or something like that, your default sort of knee-jerk reaction, this would be just a general tip for everyone out there. Your knee-jerk reaction should not be, no, you can't do that, or no, we don't allow pets. So, no, you can't have that animal here. Your knee-jerk initial reaction shouldn't be no. Sort of, it doesn't necessarily have to be yes either, but ask, the questions, get more information. Oh, okay, you're requesting to have an animal here. We are a no pet building. We're going to need more information about what your request is and to support your request. Don't necessarily just right off the bat, no. If you get anything that resembles any sort of question, don't start with no. Okay, that's my initial tip. But unlawful inquiries. So it's unlawful for an association to ask if an applicant for a dwelling has a disability. So if you have a sale application or even a tenant application, there shouldn't be a line on that application, hey, are you disabled? Don't put that on there. Or if the person intending to reside in the dwelling or anyone associated with them, so again, another occupant or whoever it is, a child, spouse, whoever, has a disability, don't put that on there. And then about the nature or severity of a person's disability. These are things that should be sort of common sense. You don't want to ask those questions because you're going to end up probably on the wrong side of a discrimination complaint, but we're putting it in here anyway, just so you see it nice and clear. Reasonable accommodations and reasonable modifications. Okay, let's get into what's what and what those words mean. Reasonable accommodation. Under fair housing, a reasonable accommodation is a change or an exception or an adjustment to a rule or a policy or a practice that you have in the community. The easiest, clearest example and what we're going to get into is if you are a no pet building. that is essentially a restriction that you have, and you may have to make an exception to it in certain cases, or an exception to your no animal policy. Let me say it that way. A reasonable modification is a little different. That is a structural change made to the premises. So think of a modification as changing sort of a physical change. Think of it that way. So that's something where maybe someone needs a ramp in, in the parking lot or from a sidewalk because they have a wheelchair and they can't otherwise access their parking space. And they may need a reasonable modification to the common element sidewalk. That would be a modification as opposed to an accommodation, which is related to basically making an exception to a rule or a restriction you have. And now someone with a disability, it could be either, it could be both, depending on what the request is. If you get a properly supported request for a reasonable accommodation or a reasonable modification, you have to permit that person who is disabled and needs this change, basically, the opportunity to use their dwelling. So you're going to have to approve it if they give you the right documentation. Now let's get into that a little more. Reasonable accommodation. So like I said, it's unlawful for any person to refuse to make the reasonable accommodation in these restrictions, in these rules, in these policies, because again, that accommodation is necessary to afford a handicapped person the equal opportunity to use and enjoy their dwelling. So you're going to have to, as the board, as management, as the association, you're going to have to make these changes potentially, either again to a restriction or to the physical space. If we're talking about assistance animals, now that's, requests are going to be made for a reasonable accommodation. That's the category of requests we're in here, so that a disabled person can have the assistance animal in the community. Now let's dive into assistance animals here, guys. So association procedures, and we're going to start with a general tip that even though you don't necessarily have to have a formal procedure in place to handle these requests, we would suggest that you do have some sort of policy procedure in place for these types of requests. If you have, in our experience, we've seen that the HUD agencies like to know that the board has sort of already considered, what if we get one of these requests? How would we handle it? What would we do? We have a sort of a packet, we have a form, we have a request form that we could give someone, maybe a new owner, maybe a new tenant, maybe a new resident who might make some sort of indication that they would need a reasonable accommodation. How would we handle it? We already have a packet put together. That looks good for the association. That looks like you're already sort of thinking about these things, and that might help you if you have a discrimination claim down the road. It's just a good thing to have. It's good business practice. We would suggest, having a policy in place, having a procedure in place. However, having said that, even if you've adopted a package and a request form and all of that, and your attorneys, Kaye Bender Rembaum could prepare, have put together this package for you and have told you, here's what we do when we get it. We hand this to the owner, to the tenant. We tell them, here's what you need to fill out, XYZ. That doesn't mean if that person does not necessarily follow that specific procedure and they don't give you your specific form back, you can't say, well, now we can deny the request because you didn't fill out our form, you didn't follow our procedure. So too bad, too sad. That's a no to your reasonable accommodation request. You cannot do that. That will not work. It is beneficial to have those forms and to have a policy in place, but you cannot refuse a request just because they didn't necessarily follow your procedure and they didn't necessarily use your form. So keep that in mind. That's very important. We don't want boards going back and saying, well, you didn't fill out our form, so we're going to deny your request. That's going to get you in trouble. All right. So the request, starting there, a disabled person is not necessarily entitled to receive the accommodation unless they've requested it. We're not psychic here. We can't know that they need to do this or that they are, need something. So they have to request it. That makes sense. Fair housing does not require that the request be made in a particular manner or like we said, or a particular form or following a certain procedure. That is not laid out by the Fair Housing Act, or at a particular time. So that doesn't necessarily mean that someone has to make this request to you before they move in. And we hear that a lot. We hear a lot of complaints of, you know, we didn't know this person had an animal until a month after they moved in. Well, that doesn't necessarily mean you get to say no to that request. The person with a disability does not need to personally make the request. It could be made by a family member or somebody else acting on their behalf. So maybe it's, you know, maybe it's the owner asking on behalf of the tenant, or the tenant, but it's on behalf of the spouse or whoever it is. That's fine too. That doesn't change how you're evaluating this request. The individual does not need to specifically mention fair housing. There are no trigger words. They don't have to specifically say, I am requesting a reasonable accommodation. And if they don't use the magic words, you can deny it. That is not the case. They do not need to use magic words. So you'd have to, essentially it has to be a reasonable interpretation that they are making a request and that you understand what the request is. And again, could be at any time, even after the animal is already moved in, basically.
I have a question that came in. Apologies, real quick. Just for someone already living in a no pet building that ends up needing a pet, they understand the need to make an exception for that. But why does our no pet building have to allow new buyers to come in with a service animal when there are plenty of pet friendly buildings? And that's coming from Carla Palmori.
Well, Carla, and I appreciate that. I do. But that's essentially the basis of this whole thing. Because if you were to say to people, no, you can't live here, that is discriminating against someone with a disability. That's the whole basis of the Fair Housing Act. Because essentially that's why you would be saying no. You're saying no because they're disabled, because they're asking for this animal and all of that. It's, again, it's hard to think about in terms of, and I get it, my disclaimer here, I understand, we know, we've seen these requests, we know how it goes. I know there's a lot of fraud in it. I know there's a lot of, and I hate to say it, but there are a lot of requests that are not valid. I know that. I know it's a lot of people trying to sort of game the system and work around moving into a building with an animal when maybe it was a no pet building, but they wanted to move in and they wanted to take, Fluffy with them, and they magically, developed a disability. We hear it all the time. I'm aware, I know. But you can't think of those cases. You have to think of it in terms of, really think of a blind person with a seeing eye dog. You would never say to that person, oh, you shouldn't move in here. Why don't you move somewhere else? Because very clearly you would be discriminating against someone with a disability. Can't do that. It's illegal. I mean, that's the way you have to think of all of these requests. Put yourself in the mindset of, without sort of thinking default is this person is full of baloney. Think of it like, what if this were a seeing eye dog? That's the easiest way to think of it, and to sort of change your mindset and to put yourself in the place of, how do we handle this? Think of the animal as a seeing eye dog. It's the easiest way to sort of get your brain to process the information properly. Because that's exactly what this is. If you were to say to someone, you can't move in, we think you should live somewhere else because you have an animal, because you're disabled, you see how now you're very clearly discriminating. Can't do it. So, all right, what type of assistance animal is it? Once the association receives a reasonable accommodation request for an assistance animal, start with, all right, what type of animal is it? There are two different types of assistance animals. An assistance animal is kind of the overarching category, but we have service animals and support animals. Service animals, and this is what we just sort of touched on, so I'm glad that was a good transition point there. Service animals, the ADA has a definition of a service animal. It is a dog only, that is individually trained to work or perform tasks for the benefit of a person with a disability. So exactly what I just said, seeing eye dog is the clearest, cleanest, easiest example for everyone to consider. There are other service animals that are trained to do other things. We had a case with an owner or with a tenant who had an animal. And again, this person did not appear to have any disability, no obvious apparent disability at all. but it had they had a service animal, and the service animal actually sensed when the person was going to have a seizure. And this was one of those cases where management wasn't so sure if that was legitimate and maybe thought that the owner was maybe not being so truthful. And the manager told me after, they actually witnessed the dog start barking in the management office, and 2 minutes later that applicant had a seizure, and they had to call EMTs and all this, and again, you wouldn't necessarily have known that, but that was a service animal. That dog was trained to alert the person that they were about to have a seizure. So service animal, it is a small definition. It really means a dog that is trained to have specific, perform certain tasks. Any other animal, if we're talking about, whatever other type of animal, it's not going to be considered a service animal under this definition. The ones we see most likely the applications for, and again, I'm being honest with you guys here. Most of the applications that you're going to get, most of the applications that we see for our clients are for what they call comfort animals or emotional support animals or companionship animals or that type of thing. Those are not service animals. That is different. So if we're going to, how do we figure out, is this animal a service animal? Well, start with, is it a dog? Yes, moving on. If it's not, could be a different kind of assistance animal, but it wouldn't be considered a service animal. If it's readily apparent that the dog is trained to do work or perform certain tasks. So like I said, if it's a seeing eye dog, you usually can tell just from looking at what's going on that that is a seeing eye dog, and you know exactly what they're trained to do, and sort of it stops right there. So is it readily apparent that the dog is trained? If the answer is yes, stop right there. We're done. The animal's a service animal. We don't need to ask any further questions. If it's not obvious, you can move on to sort of the next level of questioning here. So again, readily apparent when we're talking about a seeing eye dog, maybe pulling a wheelchair, something like that, that's going to be open and obvious. We don't need to ask any further questions if we already know. Is this a service animal? Continuing with that. All right. Is the animal required because of a disability? Yes. And the task and the work is identified. And again, if that's the case, sort of our inquiry stops and we're granting the request. No. So maybe the animal is not a service animal, but again, could be a different type of assistance animal, and we could still have to approve it. So we keep going.
Emily?
Yes.
On that note, since we're kind of headed into support animals, is there a limit to how many support animals you can have?
We're going to get to that too.
Super.
Yes and no, but we'll get to that. So if it's not a service animal, could still be another type of support animal. A support animal is a trained or untrained animal. So again, does not need to be trained, does not need to have any special skills, perform tasks, any of that. And it provides therapeutic emotional support. That could still be something that is legitimate that you have to approve. And it's just a support animal. It's not a service animal, but there we go. And now, doesn't have to be a dog either. Could be basically any animal that you keep in a household, cat, bird, whatever. Now, unique animals, that gets a little more complicated. And I know someone's going to say, what if they wanted to have a 10-foot gator in the condo, and that's their emotional support animal, allegedly. Keep in mind, these are supposed to be reasonable accommodations. So it has to be reasonable. I don't think it would be reasonable to keep a 10-foot gator in a condo. But again, we'd have to look at it sort of on a case-by-case basis and what the story is and what the documentation is and what the request is. So similarly, that's along the same lines as, well, what if I need, 10 emotional support animals? Or that's the request. Can I keep, a pack of 10 dogs in my condo unit because they're all my emotional support animals according to whatever this person's request. Now, this gets a little complicated because again, these are complicated questions, guys. But basically, there could be a case where multiple animals are permitted. You'd need to have basically proof or the request to support why they need each animal. You can't just say, well, I need an emotional support animal, so if I need one, I need 10. No, it might be I need 2 emotional support animals, either because they're whatever, they're brother and sister puppies that I've had my entire life and they could never be separated, and I need both of them. And basically you have a doctor who would sign a letter to say, this person needs both emotional support animals. But there is some leeway in terms of when they send these requests. If they are requesting multiple animals, you can ask for support for each animal, not just, I need an emotional support animal, so fair game. Now, I have seen a complaint where someone had, I think it was like 4 parrots or 4 birds, and HUD was investigating because the association had denied them the request to be able to keep 4 birds. So I don't know how that would have eventually panned out. I think the association ended up settling it, but it just depends on the request, depends on the support provided. So you really, with any of these requests, you want to talk to your attorney before you deny anything and get more information. Because if you're on the wrong side of a complaint, you're dealing with defending a complaint, you're dealing with attorney's fees. Your insurance defense might pick it up, but maybe not, maybe. And again, you're paying that deductible. And these are attorney's fees that you don't necessarily get back even if you win. So, again, dealing with discrimination claims it's not easy. Establishing the disability, we have to look at the disability. Does the person have an observable disability? If that's the case, if it's open and obvious, if the person is very clearly blind and has the animal, maybe has a walking stick, something like that, where you can see the disability, you don't really need to ask any more things about the disability. If it is not obvious, so in the case where I said, this person had a seizure disorder, you would not know that necessarily just looking at the person. Now, again, if we're talking about disabilities that have to do with the emotional, mental types of disabilities, again, you're not going to see that necessarily, and you might need to ask more information about the disability. Has the person requesting the accommodation provided information that reasonably supports that they have a disability? If so if this request has now made it clear what they're requesting, what the disability is, and sort of we're at that stage, then we would move on to, okay, then how do those two things sort of go together? If they have not given you the information that supports they have a disability, then you can, again, request more information, or we're not at the point of approving yet. So establishing the disability, they can provide you with some information. You could get receipts of your disability benefits, things like that. Again, we won't read through this word for word, but just because they don't have those things doesn't necessarily mean you can say, well, then I don't think they qualify as disabled. No, you need to look at what they've provided to you, maybe ask for more information. It's because it doesn't necessarily mean they wouldn't qualify under fair housing. They may provide you with just a letter from a practitioner, a letter from a therapist, a letter from, a prescription from a therapist, something like that. All of these things would need to be evaluated. You'd want to talk to your attorneys. Some of these disabilities, as we just said, don't necessarily or aren't necessarily very obvious. You wouldn't necessarily know that someone has, and here's the big list here. You might not know that someone is schizophrenic or has major depressive disorder. These are things that wouldn't be obvious to you. They may present you with information that is the case. And then again, you'd have to treat that appropriately. Now, if you do get information about the disability, now the question is, okay, so what's the need necessarily for the animal? What's the connection? So we have that they're disabled, that it impairs at least one or more of their major life functions, and they have this request for this assistance animal or for this animal. What's the connection between the two? So, again, what's the nexus here? We get the documentation from whoever it may be. So like I said, it's typically the practitioner, but it could be a therapist, it could be a psychologist, it could be a nurse practitioner or a nurse even. Doesn't necessarily have to be the, MD. Whoever this would be to provide you with the documentation needed. We want to look at the connection between that disability and the need for the animal. So if it's, this person the disability is that this person has anxiety and depression, and the animal provides them with emotional comfort and security and confidence and things like that, that's the connection. essentially. It doesn't have to be something as, tangible and obvious as the dog alerts them when they're going to have a seizure. It could just be something like emotional support. That is a legitimate basis for a request, but we want to make sure we know what that connection is and what the request is. If we don't get that documentation, that could be a reasonable grounds for denying a request. If you go back to that requester, whether it's a new owner or a new tenant, and say, okay, well, you've requested to keep Fluffy here. We're just going to need some more information. We need to know, again, what your disability is and how that animal is helping you with that disability, basically. And they don't give you anything. You never get any response from them. You would want to follow up. Hey, we need some documentation from a qualified professional, and they just don't send you anything. Then, okay, well, we didn't approve your request because you didn't send us anything. But again, we would want you to sort of make sure you're reaching out. You're making this an interactive process is what HUD wants to see. Now, we always get questions. What about these internet, certificates, badges, vests that are sold where you log in and you pay $69.99 and all of a sudden Fluffy is a certified, support animal or whatever it may be. Now, just because someone has done that or has presented that to you, that's not an automatic, well, we're denying your request because we think it's fraud because this is a website, printout. Don't start, again, never start from a position of no, but those websites, we're aware, and HUD is aware that those are not necessarily valid, but it doesn't mean that the request isn't valid. So the website information alone is not going to be enough. We can go back and we can ask for more supporting documentation. We want legitimate, healthcare professionals to provide this information. And sometimes some of those websites do that because there is, sort of remote work available now. Official records, something to be aware of. This is another sort of a practicing point, especially if you're a manager here. Anything you get with any of these requests is going to be part of the official records, but there are exceptions, as you should know, things that should not be provided as part of an official records inspection request, documents that are part of the official records but not open for inspection, and those basically cover anything you're going to get here. So these would be documents that would not be open for inspection, even though you have to hold on to them. So, anything that involves medical records, if you get an owner who makes a request for an emotional support animal, an assistance animal, whatever they may call it, they're probably going to send you a letter from a doctor or maybe really just medical records. Those things should be kept, cannot be open for inspection. Social security numbers, driver's license numbers, things like that. And that's for condos and HOAs. So make sure, if you have a request and you have any supporting documentation, that information is not open for inspection to other owners. Types of animals, we touched on this a little bit. Is it something commonly kept in the household? All right. So basically, if we have everything else lined up to support the request, yes, we're going to allow it. If it's an animal that is not commonly kept in a household, we need to look a little bit further. So the easiest example here that we had put in, there was a case with a trained monkey. So again, not a normal sort of animal you think of when you think of household animals, but the monkey specifically had an advantage over maybe this person having a dog because the monkey has, basically, can open a water bottle and can get things out of the fridge and things like that, and do certain tasks that a dog wouldn't be able to do. Now, the question is, what about an animal that poses a direct threat? Now, I keep in mind that this means that can't just be, hey, this person has a pit bull and we think pit bulls are dangerous, so we're going to say no, even though the animal otherwise has all the documentation to support that it's an emotional, support animal. So something like that where you say it's a dangerous breed, it's a pit bull, it's a Rottweiler, whatever it is. So we're going to say no because they're dangerous and it's a direct threat. No. Let me stop you right there with that thinking. The animal has to pose a direct threat. So it can't just be because we think it's a dangerous breed. It has to be a direct threat, such as specifically Spot has been on this property before. He's, that dog was here. He came to visit a couple times before this person moved in. We've seen this animal, and the animal actually lunged at a number of people. It bit somebody in the elevator. It actually has a history. That animal has a history where we can actually track that it poses a threat to our community. Not just it's a pit bull, so it's a threat.
Emily?
Keep in mind. Yes.
I apologize for interrupting.
No, it's okay.
In line with, this kind of goes in line with it. How do we protect this is a medical question, but it's kind of affecting other homeowners. And how do we protect existing owners who have severe allergies to animals from the new owners who move in with their emotional support animals? Now I get it, but are you sharing space, or how does that work? Or
yes. And again, you guys are hitting on sort of varsity level questions here. That's next level if we were doing a sort of a 3-hour fair housing class today, but very good question. And that is a real concern, and that's a real problem in a lot of these cases. The issue is essentially it turns into sort of this competing disability situation. And we've had this come up, and this is a problem, and it's a problem for HUD, and we don't really have clear answers on the best way to deal with it. That's why we want to look at your specific situation. But it could be something where essentially, unless there's a documentation or a documented disability prior, so if you already have an owner that has, for whatever reason, already let the board know or let management know, I have severe allergies, maybe they told management, I carry with me an EpiPen, I have severe allergies, I need to make sure, XYZ. For whatever reason, the association already has a record of this. And then someone wants to move in, and it's going to be, lo and behold, they're moving in right next door. They share the same elevator. They share the same vents in the hallway, things like that. That could be an issue where now we have competing allergies, competing disabilities. So there could be a problem there. It may be something that the association has to deal with. And again, I would just really look at it on a case-by-case basis, or it could be a separate issue where it's just someone who has allergies. But as Jerry just said, maybe they're not sharing space. Maybe they're on 2 different sides of the building. They don't use the same elevator. You really aren't going to really run into each other. Maybe they're outdoor catwalk hallways, so it's less of a concern. These are all things you're going to have to look at on a case-by-case basis. Maybe there's a way, sort of a workaround, but we want to look at it all on a case-by-case basis and deal with it that way. It's not easy. There's no clear-cut answers here of, well, we have someone with allergies in the building, so we have to tell the person who's requesting to bring an emotional support animal, no, that's not going to work. You have to really look at it and see if there's a way to sort of address it. And that actually leads us to this next slide. It's an interactive process. You have to look at it interactively. You might have to get HUD involved to offer some guidance, but you can't just deny a request if you're not sure. You have to go back, you have to get more information, potentially, all of these things to figure out sort of what's best. If a request is refused, then you have to look at alternative accommodations. So again, maybe, and we can, again, it would be on a case-by-case basis here. You can't request the applicants, these are key points here. You can't request that these applicants pay any fees for these animals. So now here's an important point. Even if normally you charge a deposit for a pet, so maybe you're a building that does allow pets, and maybe it's, a dog up to 20 pounds, and somebody has made this request, well, actually, my dog is 80 pounds, but it's my emotional support animal. You would have to allow that, even though you're a pet building that has a restriction of 20 pounds per dog. You would have to allow that because that's where the reasonable accommodation is, if they've given you the proper documentation. But if normally you charge a pet deposit or some sort of pet fee or pet whatever it may be, if there is a fee associated with that, you cannot charge it once it's now considered an emotional support animal, assistance animal, whatever, other type of animal as part of a reasonable accommodation. You are not treating that animal as a pet anymore. That is a very important point. It cannot be treated as a pet, should not be treated as a pet. So you have to separate in your mind, oh, we charge a pet fee. Well, too bad. That pet fee does not get charged against that 80-pound emotional support animal. Can't do it. You can't ask them for, certain medical records and more detailed information about their impairment. Can't do that either. Can't unreasonably delay your response. That could be considered basically a rejection, and you could be subject to a complaint. Now, we get this question all the time. We already touched on it a little bit. Where can these animals go? What does that mean? Can we bring the animal all around the building? Can we tell the person they just have to keep it in their unit and that's it? Well, essentially, the animal is supposed to be able to go anywhere that the person can go on the property. Now, there are some sort of rules we can adopt and some limitations we have to look at if that imposes a financial administrative burden, if there's maybe a health issue, if it alters the nature of the housing provider services. Typically, the rule is, the animal shouldn't be in the pool, shouldn't be in the kitchen of the clubhouse, because there are sort of health and sanitation concerns there. But you'd want to see, is there a reason that animal needs to be in the pool? Again, maybe if it were some sort of seeing eye dog situation, maybe there's a reason that animal needs to be in the pool, on the pool deck, something like that. Whereas normally you would probably not want that to be the case. But again, we want to look at it on a case-by-case basis and what that animal is doing. But generally, ballpark response is the animal can go where the people can go. So you can't say, well, we'll let Joey have Fido, but Fido can't come into the clubhouse. No, Fido can come to the clubhouse. Now, we can adopt certain rules. That's what this slide is all about. But like I just said, we already touched on a couple of these points. Weight, breed, size restrictions. If you have those already, maybe you are a building that allows dogs already, and you have a weight restriction or a breed restriction or a size restriction, those do not apply, and you cannot have them apply to any type of assistance animal. You can't say, well, we're cool with you having an assistance animal as long as that assistance animal is under 40 pounds. Absolutely not. Because again, put the hat on where you're thinking that this animal could be a seeing eye dog. You would never say to a blind person, your 100-pound golden retriever can't come in because we have a restriction and we only allow 40-pound dogs. You would never do that. That's the mindset you need to sort of be in here. The board can adopt additional rules, reasonable rules, but you want to be very careful on what those are. Talk to your attorneys and make sure they don't run afoul of any fair housing issues. We talked about the number of animals. Now, keep in mind, if you have, maybe you are, as we said, maybe you are a pet building, maybe you allow one dog and someone has now moved in with a second animal and they say to you, well, but the second one is my emotional support animal. You're not allowed to say, well, but you already have one dog, so too bad, you can only have the one, can't have the second one. If it's an emotional support animal, assistance animal, service animal, whatever it may be, again, it comes out of the tally, because if you have a pet restriction, that animal is not a pet. If they've already given you the documentation, it's properly supported, that animal is not a pet. So you have your one dog that they moved in with, that they considered their pet, and then they could still have a second animal as their reasonable accommodation. Or same thing, if you have a limit of 2, arguably they could have 3 pets, 3 dogs, 2 being the pets, 1 being the reasonable accommodation. For violations of the Fair Housing Act, that's what we're trying to avoid here. We're already an hour in, so I won't get into sort of the technical things here, but there's a lot of information on how that works. The agencies that will follow the process. Like we said, HUD is really who's going to be on the other side of it. They're going to be investigating these claims. That's who you're going to be responding to for the most part. They can find that there's been a violation. They can, hit you up with some penalties here. Those are all things to read through. We'll give you all the information there. It's all in here. We've included some cases. So you guys can have really, really specific examples. You can read through the case law. That's all in here. We put a lot of information in here so you can read through it and get as much as you can out of it. Jerry, I know there's some questions. I figured let's jump to those.
Okay. Yeah, I'll kind of go in order, but we have a question from Susan Snyder, she asked quite a while ago, and she's asking if guests that come with ESA pets in an association where.
Yep. So it's the same kind of thing. Basically, if you have a guest that regularly comes with an assistance animal. Now, again, if you have a guard or a gatehouse or security or something like that, and the person shows up with an animal, and you're, let's say you're a no pet building, I have no problem saying, oh, ma'am, this is actually no pet building. Not sure if you're aware of that. You really shouldn't be bringing the animal here. And then wait for the response. Well, actually, it's my emotional support animal, or it's my assistance animal, or it's whatever it may be. And then okay, well, that's great. If you want to continue to come visit, Mr. Smith, and bring your animal, we're going to need that information from you so we can accommodate you. It's the same kind of thing.
Okay, next question. Does zoning restrict any type of animals allowed?
Yes, that may be something that could sort of come into play as well. You could have something like that where, again, not to sound totally crazy, but a really exotic, animal, somebody wants to move in with a Florida panther. I'm guessing you're going to have some zoning or regular local ordinances that wouldn't allow that anyway.
Or a donkey.
Right.
So daughter of an owner has an ESA and now buying a puppy and wants to add it to the ESA. Is this an automatic acceptance?
I like the way you said it, is an automatic acceptance. So we already know this person has given us the information. They have an approved request. They have an emotional support animal. And we touched on this a little bit. If someone wants a second emotional support animal, or again, if in general you get a request for 2 assistance animals or 2 animals, you can ask for specific, support for the second animal. Why do you need the second animal? But ultimately, so it's not an automatic, well, she already has one, so she gets the second one. You can ask for the documentation. And I mean, ultimately, being realistic, she's probably going to get you the documentation, but at least now you've done your due diligence, you've requested it. And it should indicate that, again, from whatever professional she gets, they should indicate that she needs the second animal for a particular reason, not just, well, because we already told you she needs an emotional support animal, so 2's better than 1. That response wouldn't cut it. You need to actually have a connection there as to why they need the second animal.
And it could be an aging pet they're going to eventually replace too.
Right. Right. There could be a completely legitimate reason. Well, Fluffy is about to pass away. And to deal with the stress of this animal passing, she needs the new animal to help her, with the transition. There could be a completely legitimate reason. And, we can't predict it, but could be. And that could be something that you would have to approve. Can the association restrict a leash to 6 feet? Hi, Robert. That is one of the rules that essentially you could put in there, some sort of rule that the animal needs to be under its owner's control. So you can't request that, the owner necessarily carry the animal through the lobby. We've seen boards that have tried to have that rule in place. Now, again, that doesn't work because default back to what if it's a seeing eye dog? You wouldn't tell someone you have to carry your 100-pound golden retriever through the lobby. You wouldn't do it. That shouldn't be your rule. But you can have a rule that says the animal needs to be under the owner's control. So whether that be with a leash, or if they are carrying them, or if they're transporting them with a cage, a carrier or something like that through the lobby, a rule like that should be okay. Now, again, there could be a reason that person tells you that doesn't work for them because of the nature of their disability or the nature of the animal, but you'd want to look at it. But generally, that type of rule should be okay. May the association ask to remove the pet if they're not following the rules? So again, you should have certain rules in place. The animal shouldn't be a nuisance. You don't want the animal to, even if it was a properly documented and supported request, animal, you don't want the animal moving in and then biting people in the elevator or barking all day long and driving the neighbors crazy because the dog just barks all day, all night into, all hours, very loudly. All of these things that could be an issue. Or like you said, if the owner doesn't keep it on a leash and the owner just lets it run out and go to the bathroom wherever it wants and run back into the, back into the condo because they live on the first floor, whatever it is. All of those things, you want to handle them very carefully, but ultimately, yes, you can hold the owner responsible. They are still supposed to be following these rules for these animals. And if they don't, potentially that could be cause to remove the animal or to ask the person to remove the animal if they don't come into compliance and if they don't start following these rules. You would want enough documentation to support that. So it wouldn't necessarily be the first, request. Hey, you let your dog off the leash, so it's got to go. You want to work with these people and make sure you're, sending notices, you're documenting these violations, and you have enough support before you say the animal has to go. Give them a warning, let them know, hey, animal needs to be, properly controlled. You can't be doing this. We need you to fix that. Otherwise, the animal is not going to be able to stay here. Something like that. Can you stipulate an elevator for ESA use? Good question. Generally, no. You should not be sort of saying, hey, if you have an animal, it has to go in this elevator. Can't use elevator 1, have to use elevator 2. Because again, the animal should be able to go anywhere the owner can go. Now, again, hypothetically, if you had one of those situations where you had someone with severe allergies, then maybe it would make more sense. And those elevators have to be very, similar. You can't say you have to take the service elevator that's way in the back that, goes through the parking garage and you have to walk around. You're not going to be able to do that because you can't treat the people differently. But if you had 2 elevators, hypothetically, 2 elevators that were side by side, looked the same, essentially same manner of access, things like that, and you had a case where somebody maybe did have severe allergies that you'd already documented, and you have someone with the animal, maybe there it would make more sense. Okay, please, we're requesting that you please use this elevator. But again, that's a very specific situation. Otherwise, no, you shouldn't be specifying that the ESAs have to use a specific animal or specific elevator. Let's see. Could amending governing docs to use the phrase domestic animal instead of pet control fraudulent attempts to have 1 pet, 1 ESA, 1 service dog, since all 3 are different? I don't think that's going to help you. I think no matter what, basically if they have the documentation to support the request, they're going to be able to have the assistance animals there. I don't think that's really going to get you where you want to be. Do you need a copy of a letter that your pet is a service dog? So again, we talked about that a little bit. Yes, documentation should be provided to the association. Again, if we're talking about a service dog, a dog that is trained to do certain tasks and the disability is open and obvious, if we're talking about an actual, seeing eye dog, then no, you probably don't need a letter from a doctor if it's open and obvious. But for the most part, you should have the documentation to support the request. Boca Raton dogs are not allowed on the beach. Does that apply to AS dogs? I assume that means assistance dogs. Good question. Not a fair housing question, though. That's really for, I guess that would be an ADA issue. Odds are, if it was an ADA, if it was an actual service animal, because again, think seeing eye dog, if it was a service animal, that service animal most likely could go to the beach, I would assume. Where can I get a list of what animals are considered emotional animals, ferrets, iguanas, so forth? Basically, again, unless it's something very unusual and or dangerous, most animals can probably be emotional support animals. You could check HUD's website if they actually have a list, they may, but it would be whatever the documentation says. You'd have to just look at it. Oh, this is a popular question we get. Can someone leave the emotional support animal in the unit while they go on vacation? Or can neighbors look after it? Or can, somebody else come and walk the dog while they're on vacation or something like that? Yes, they can. I know everyone goes, well, but if it's their emotional support animal, how come they can leave it for a week? Why can they go to work every day and they don't have to take the animal with them? And I understand that mentality, but that's not sort of the way you want to look at it. If it is a properly documented and supported, approved emotional support animal, assistance animal, those people can live their lives. They can go on vacation, they can go to work. The animal does not need to be with them, 24/7.
Can I cut in for a second?
Yep.
Because we mentioned earlier, folks, while we want you to stay for the Q&A, you're not required to. And I promised that I would do the evaluation overview real quick before you continue with the question. So I just need about a minute here.
I think we're pretty much done. You can wrap it up. I know there's one more question about a number of animals, but we sort of touched on that. You would just need the documentation to support it.
Okay. And on that point about, animals and work and stuff, it's a valid point because you know, to me, for instance, I don't need an animal. I wouldn't, going to work is not stressful for me, but going to an airport is stressful for me. So there are different situations that may require something. So I get that point.
Well, everybody, thank you once again for the privilege of your time. I hope you found this informational. Remember, it's informational and not legal advice. If you should decide you need that, please feel free to reach out to Kaye Bender Rembaum. I'm sure they'd be happy to help, or to your association's attorney. And if they can't answer, go back to what I just said. So on my part, I'm so appreciative that you've allowed Associa into your day. And Emily, Jeff, I can't thank you enough. Always a pleasure to work with you guys. And I look forward to our next encounter and webinar.
Thank you. Thanks, Jerry. Thanks, everybody.
Thank you. Agreed. Have a wonderful holiday season, everybody.